All right, sorry about that. We can start now. My name is Hussein Mahadi, and I'll be our moderator for today's session on artificial intelligence and technology. As we all know, the topic for today is safeguarding IP, intellectual property in the age of artificial intelligence, protecting creation generated by AI, with a focus on ChatGPT. That's ChatGPT as a case study. We have four mentors for today's session: Mr. Matt Harvey, Professor Samuel Samai, Mr. Gabriel Udo, and Vice Isaac. We have Prof. Samuel Samai on the call. Please let's all join me to welcome him. Thank you very much for joining us today. We look forward to hearing from you on the topic. Quickly, I'll be sharing the screen of our mentors. Okay, I hope you can all see my screen. This is the profile for Professor Samuel Samai Andrews. As a faculty member at Al Yamaha University, he teaches IP law subject, engage in research and curriculum development, teach some core law courses, and explore international comparative law and international law. Particularly, he explores how sharia law interfaces with innovative creative regimes of other legal systems, civil and common law legal systems. He has over 30 years of experience in the field of intellectual property law, both as a scholar and as a legal practitioner. And he holds a Doctor of Judicial Science, SJD, degree from Suffolk University Law School, Boston, Massachusetts, USA, and LLM degree from University of Washington School of Law, Seattle, USA. He is also an IP rights manager for the African creative industry, particularly Nollywood and African films, and the USA Ambassador's Distinguished Scholar. He taught and carried out scholarly legal research on intellectual property law at University of Gondar. He has published multiple scholarly articles on various aspects of intellectual property law. He has copyright technology, digital regimes, traditional indigenous creative rights, and transnational perspective. He is passionate about and advancing the understanding and protection of intellectual property rights in Africa, the global South, and beyond. He enjoys speaking and teaching on this subject. Thank you very much once again for joining us today, Prof. Um, I can see Mr. Miles is also on the call. We are with Mr. Gabriel and okay, Mr. Matt just joined the call. Thank you very much for joining us today. Quickly, I would also be reading other mentors' profile before we jump into um, the topic for today. So Matt Harvey is the head of AI law and partner at Glowing WLG UK LLP, advising on AI across all sectors. He is a co-editor and of the Law of Artificial Intelligence, Sweet and Maxwell. He is a trusted intellectual property advisor, especially for clients with complex patent disputes, including SEP, fraud, litigation, legal 500, has described him as standout and absolutely superb for patent disputes. His case have involved video compression, telecommunication, 2D, 3D, LTE, DSL, and other standards, aircraft design, software algorithmic, algorithmic training, consumer share trading platform, 3D modeling and consumer electronics, inkjet printer, location sensing and traffic analysis. He has extensive experience in healthcare and life science work. His works include monoclonal antibiotics, biosimilar toxins, medical device, and cosmetics. He has handled products clearance and disputes involving copyright, trademark, design, and confidential design for clients in aerospace, retail, fashion, automotive, and financial service sector. He successfully defended the Kennedy Trust for hematology research in the UK-first biosimilar dispute and helped with Fujifilm's Kyowa Kirin Biologics Co. Limited. I'm sorry for my pronunciation. First UK Arrow Declaration. Thank you very much for joining us today, Mr. Matt. Our two other mentors are Miles and Gabriel Odo. So quickly, let me just read their profile before we jump into the topic. Miles Isaac is an undergraduate of King's College London, where he is currently pushing his bachelor's degree in philosophy. Miles is an artificial intelligence enthusiast. He is a member of the International Churchill Society and the Royal United Kingdom Institute, UK. And lastly, Mr. Gabriel Odo is the last mentor for today, although he's not on the call yet. Gabriel is a research fellow at the Robotics and Artificial Intelligence Law Society, Wales, Berlin. He has, with a strong passion for the intersection of AI, law, ethics, and society, he is a PhD candidate at the Europa Università Vadrena, focusing on expertise, focusing on the law and ethics of autonomous weapons system. His expertise spans topics like robotics, smart city technology, digital colonialism, and privacy. He is also a proficient. He is also proficient in Python programming and data analysis. That's our last mentor for today. Quickly, I'll be giving the floor to Professor Samuel Samai to give us an overview of the topic. Once again, our topic for today is safeguarding IP in the age of artificial intelligence, protecting creations generated by AI with a case study of ChatGPT. Thank you very much for joining us, all our mentors and our mentees. Over to you, Professor Samuel Samai.
Okay, good afternoon, everyone. Thank you for inviting me, JIIPCC. I'm just trying, I have a short, my eyes are kind of really bad today. I don't know what's going on. Okay, can you see what I'm sharing? I have a short thing.
Yes, sir.
Have you seen
Yes, sir.
I shared
Yeah.
a document? You can
Yeah,
see,
we
I'm
can
trying to
see
put
your
it here.
screen. Okay, sir, your voice is breaking. I don't know if I'm the only one having that issue.
Can you hear me?
Yes, we
My
can
voice
hear
is,
you now.
my voice is breaking.
Yeah, it was breaking just now.
Well, I'm trying to set up to put it in presentation mode from my end here, but it seems to be frozen here from
Okay.
my side. And then okay, all right, I'll leave it here. So yeah, like I will leave the technical details for Miles and my other colleague. But generally, what I want to do right now, I want to discuss where we are in the old ecosystem and legalese of AI. You know, AI has been in prominent discussions now all over the world, and in the policy realm, and also in the law courts now. It's bubbling up in the law courts. We have recent cases that have been filed. Since AI is a new thing and it's a new technology, not really new, but its interaction with the law is kind of new. You know, law is always catching up with technology. Now, the good thing about where we are in Nigeria is that we have a modern or a current copyright law. You know, Nigeria, was it last year? We have a new copyright law that has now at least recognized what I call the digital era regimes of intellectual property, particularly copyright. So before now, our copyright law in Nigeria did not recognize things like, couldn't have recognized things like AI, because it was copyright based on analog. It didn't take care of the digital era, the software and the machine era. So now, from my perspective, AI as a whole, artificial intelligence, being in the realm of software, I think it's protected by copyright and maybe at times also by patents. But I'll be focusing on the need for up-and-coming lawyers in Nigeria, or those in the space, to follow the discussion going on right now, and also build the body of works that will help the creative industry in a country like Nigeria and other global South creative spaces. So GPTI is an example of an LLM, which is a large language models, So we are only using ChatGPT, as a case study. There are other LLMs. We know we have so many of them now. In fact, ChatGPT, there's even an upgrade of ChatGPT. We have things like BARD, we have things like DALL-E, and all the rest. That now, the current controversy, or I would say discussion right now, is how does or can we use copyright law to protect especially the generative part of AI? Meaning, we know that it's a bit technical when it has to do with AI and generative AI systems. Now, in a very simplistic form, there is a training that goes on existing. So AI uses an existing or pre-existing data or pre-existing maybe copyrighted materials to train on, so that the kind of training the generative AI on this pre-existing data, so that it can give it what it wants. So at the end of those training, the generative AI produces, in quote, perhaps copyrighted contents. Now, the controversy that I've seen personally is that there is a whole lot of argument now that because perhaps the training that goes on is in the public domain, most of those data, perhaps they are not copyrighted. They are in the public domain. So all what AI is doing is working on the back of the copyright law that says that you can use materials that are not copyrighted. Materials that are in the public domain can be used, even though originally they would have been protected by copyright. So, for instance, the case of New York Times and OpenAI, that recently was filed. New York Times is accusing OpenAI for infringing on their pre-existing text. Now, for technologists and for IP lawyers, how do we determine whether the output that a generative AI comes up with, the content that a generative AI comes up with, like a ChatGPT text, how do we determine that those texts are actually not under the traditional copyright exception or exemptions, because that is where the crux of the matter. I'm trying to narrow down the arguments on both sides now. That is where the crux of the matter is. The crux of the matter is on the copyright exemption, copyright exclusion. So the owners of AI are claiming that most of the content, the output from this generative AI infringe on their copyrighted content. But if we actually look at what copyright is all about, what's the essence of copyright? Copyright is just to protect those legal rights that the law has given permission for you to protect for a limited time. And the law does not make every creation protected by copyright. The law has given us specific things that can be protected by copyright, what I call the original principles. So if copyright is to protect literary works, is to protect things like movies, is to protect things like software. Now, how do we determine which is that is free from copying? Now, because AI, generative AI, does not produce on its own. It's using a common man parlance. It fits on an existing, it trains on an existing creation of people. So you can see that now, if there's a data, there are texts, either pictorial text, either data somewhere. These machines have to train on those data for them to be able to give us what we want, the output that we want. So if the pre-existing data or content that they are training on, if they were protected by copyright, definitely there was going to be an infringement. Definitely there's going to be an infringement. So now it's now behove on the court or the legislation to now determine where the line will be drawn. And it now behoves on us, legal scholars, to now give that bright line, because right now there is no bright line. Right now, we are still in the discussion phases. We are still in the laying policies, suggestions. I think, was it last week, the US Congress came up with a working paper after setting up a committee to look into these issues of AI, whether there's need for new laws entirely under the copyright laws, or whether there's need for a special law, a sui generis law, and all that. But what I'm trying to lay a foundation is that in Nigeria, we already have the laws in place. We have our fair dealing provisions under the copyright law currently in Nigeria, which will give us a guideline to see at what point you can actually use somebody's pre-existing data or pre-existing works to train on them to give you the output you want. So not all, I'm saying that not all generative AI outputs might be protected by copyright, but I think there are going to be some that are going to be protected by copyright, because the fact that the whole concept, the whole regime of AI is a software, is a program, it's a computer program, is definitely within the subset of creation that the copyright law protects. So on that note, I just open up the discussion and let us see how we can continue in this ongoing discussion to see how we can lay either a bright line, if we can, or either a guiding post to see how generative AI and LLMs like ChatGPT can actually aid the creative industries in Nigeria? Thank you.
Thank you very much, Prof. Samuel Somai, for the presentation and a very comprehensive introduction to the topic. I'll be giving the floor to Mr. Matt to carry on with the discussion.
Great. How long would you like me to speak for, do you think?
Oh, 20 minutes.
Oh, gosh. Okay. Well, we'll see what happens. Okay. So let me try showing my screen. Okay. There we go. So yes, I will talk on some of the overlapping themes. I've got some strange noises coming through. Is someone need to mute?
And Bofen, please.
Okay, that seems better. Oh, no.
Yeah, there's still okay. It's gone.
Okay, let's try again. Okay, brilliant. So my name is Matt Harvey. I'm head of artificial intelligence law at Gowling, and I'm also an IP specialist. And as you explained when you're reading out our biographies, I'm also general editor of the Law of Artificial Intelligence, which is a textbook aimed at UK-based lawyers explaining the legal and regulatory and ethical issues with AI, and I write the IP chapter within that. So let me talk first about two forms of artificial intelligence. Artificial intelligence goes back at least to the 1930s or 40s, and the term, I think, was coined certainly in the first half of the 20th century. So it's a very, very established concept. But what we've seen since about 2012 has been a real interest in forms of machine learning, and particularly using artificial neural networks as a way to structure artificial intelligence. And that has allowed AI to become brilliant at finding patterns. If you give it the right training examples, it can learn to emulate the sorts of classifications that humans have been able to do readily. So if I train it on audio samples with transcripts, it can learn to identify speech, and that enables voice assistants and other voice interfaces generally. If I train it on videos of labeled like these are with cars and people and structures, you can train an AI to recognize things in the street, and that will enable a self-driving car. Now, until about a year ago, all machine learning applications were targeted at a specific idea, a specific domain. And this is an example from the life sciences sector of all of the companies which were at the time working in AI and life sciences. And you were able to chart each one according to what training data they used, and that's on the left hand. So did they use training articles? Did they use scientific data? Did they use patient data? So what did they use to train it on? And then along the top, what were they actually training the AI to do? So a classic example is I get images of X-rays, which are labeled with whether someone had a disease or not. And the AI using those examples will find patterns on its own, enabling it to make the same determinations. When it sees a new X-ray, it can decide whether that shows the disease or not. And that is why these are called classifiers. You give them real examples and it classifies the result. In the last 12 months, we've been looking at something really quite new, which some people are calling foundation models. And rather than taking a very specific set of training data and training it to do a very specific task, we are now seeing AI which is being trained on the entire internet. So you scrape all of the content of the internet and you train on that. To give you a sense of scale, a modern large language model is trained not only on the internet, but also on books and emails and other texts. And we are talking billions billions of works it's being trained on. And the current crop of image generation AI is also trained on billions of images. And that allows you to create what is being called a foundation model, because a foundation model, having had such broad training, can be used for all manner of different tasks in practice. And some examples are given here about sentiment analysis or answering questions. And you may have seen that for yourself if you use something like ChatGPT. It isn't designed just to write text about a particular topic. You can ask it about just about anything that it might have encountered on the internet, and it can give you a cogent and well expressed answer, although sometimes it does hallucinate. And among the foundation models are generative AI, and the most favored versions at the moment are ones to create images. So the image shown here on the left was created using Midjourney, and the artist went through a process of about 600 prompts until he was happy with the output. But this image in particular was entered into an art prize in the States. No one knew it was it had used AI to produce it, and it actually won the award, and that shows you the quality of the outputs. And the one on the right is just an example of a large language model. I've asked it to explain what generative AI is, and it's given me a very, very good response in plain English. Quickly, I would just highlight the change in the quality in outputs over the last 12 to 18 months. So this slide illustrates 5 iterations of Midjourney. From the first, where really the images are unusable. You can tell what it's trying to do, but no one would want to use that image commercially, to what was then, I think, Midjourney version 5. We're now up to 6 actually, and it can produce images which are clearly capable of being commercially valuable now. And that development took only a year, so we are all intrigued to see how powerful it becomes in the next year or years. The other key issue is ubiquity. AI is now becoming accessible by many, many people. So I think it's true to say that OpenAI reached 1 million users in about 5 days and quickly reached over 100 million users. And Microsoft Office is going to allow access to generative AI if you pay the money through their Office suite. So it will become a technology that every single person increasingly is using. Now, let me talk to you about some of the IP issues. The first is confidentiality, and certainly some public free to use AI systems have been found to train on the inputs that people type into them and may then output some of the information they've received in that way. So there are some dangers of confidentiality. So if you're dealing with sensitive or confidential information, it's best to have a paid service where they assure you about confidentiality. And even then, some of the suppliers may end up looking at your prompts in part of their sort of quality control or making sure there's no misuse of the system. The second big issue is copyright infringement, and Professor Samuel has spoken about the cases which are ongoing. But essentially, because this current trend for training on material from the general internet is so broad, we have many questions about whether downloading images is copying, whether extracting data from images and text is copying, whether the trained model itself is a copy, and whether the outputs are a copy. And the 2 images I'm illustrated on the right are from an academic paper in which they found the image at the top within the training data used for an image generation AI, and the image at the bottom is the one they got the AI to produce when they found an appropriate prompt to do so. And their theory is that the model has in fact memorized at least some of the images in the training data, maybe not many, maybe 1 in a million images gets memorized, but when you're training on 5 billion images, that is thousands of potential copyright infringements. There are obviously cases going on, and in those cases, the AI companies are trying to rely on various exceptions to copying, the most important of which is fair use in the States, which does allow copyright infringements to be allowed by the court where the results are transformatory. And previous examples included Google Books, where Google scanned books, and when you typed in searches to Google, it would reply with extracts from books, and that was in the States found to be fair use. And so there are some people who hope that. Sorry, my computer is saying it's going to restart. I may lose you unless I can stop it. Just a sec. Okay, I may have to.
Okay, we lost Mr. Matt. When he comes back, he will be continuing from where he stops on his presentation. But before that, I can see Miles is on the call, so Miles, it's over to you.
So you can all hear me, no issues with my computer on my side.
Yeah, we can hear you.
Great. Okay, so do you want me to start, and then when Matt comes on, he'll just carry on?
Yes.
Okay. So first of all, both were presentations before we were very informative. I think that the main issues were put across the board. So I've had to refine my presentation as a result. So I'm gonna firstly outline what IP is, just like I did in previous presentation as to what AI is, because of general consensus misconceptions with regards to semantic definitions of the terms. Examples of the key 4 types of IP protection, and also the difference between all 4 of them. There are common misunderstandings when it comes to different classifications of the 4, and they each have very, very different roles. So, and then lastly, just general questions of this week's topic. So firstly, question of what is IP is a philosophically challenging question, but it really corresponds to and boils down to creations of the mind. So what an artist will create, an invention, an artwork, an online artwork, sorry, just a question. Online artwork, the even currency. So Bitcoin would have some sort of intellectual property protection since it's an online brand. Even names and images of companies and brands. So Nike or even JIIPCC will have their own logo, that of which other companies can't use, because the logo has been copyrighted. It has been even a trademark on the logo as well, which leads me on to the next section of the 4 different distinctions of what intellectual property are. So you have patents, you have copyrights, trademarks, and trade secrets. The last one is a tricky one to understand, but patents are really the exclusive right for granting the inventor the invention to know that it's them and themselves. The second is copyrights. Brands, companies will have copyright practices and copyright laws on their brands, which will protect them, protect authorship. So protect whoever has authored their brand, they protect them authorship for it being designated theirs. The additional layer of what IP is intellectual or intellectual property is trademarks, typically lending itself to words or phrases that are used to distinguish companies from other companies. So certain commerces will share similar brand appearances, and it's the trademark that will distinguish them even more so. So Nike One is some I don't know. There used to be a Nike one that was Have a Nice Day. There used to be some supermarket company ones here in the UK would have their own trademark infringement practices, which would be the slogan, and each of these three would provide different levels and layers of IP protection. Last one being trade secrets, very sensitive information, which is commercially valuable to other companies who may look to intrude. So valuable information just known to a certain few amount of people involved in that company. The important difference, though, between IP and copyright, for example, is really the different laws and boundaries that they border on. So IP being a creation of the mind will border on the law of expression and ideas, whereas copyright and or trademark will border on the expression of audio or visual law. So another question really is, why do we need IP in the first place? The simple answer is allowing IP protection gives companies the competitive shield that they need, that doesn't allow other companies to infringe on their practices. So it gives companies this competitive advantage over other companies and protects them legally, so that other companies and other people are unable to infringe, and protecting brand identity. Another another main concern of this is whether it's human production and IP should protect human production, or it's a algorithmic system production. The concerns as to whether the works of images or files or text, brand logos, slogans, trademarks are either the works of human intervention or algorithmic production. So to put this into perspective, there was a painting in the States that was a different one to what Matt spoke about, but there was a painting in the States that spoke of that was sold for I think it was $400,000, $400,000. And the painting was made by AI, and the money, the creator of this AI received the money, but there was debate about this as to whether the creator should get the money, if the AI should be protected via IP law, or if the money is really of public domain. And with regard to ChatGPT, the question here of the painting mapped onto ChatGPT allows us to ask a question of we know that algorithmic systems, AI systems, are built off large sets of data. This is where LLM comes in. Large sets of data. So who retains ownership over the AI? Is it the creator? Is it the people who provide these large sets of data, or is it for public domain? You know, should the engineers or developers claim ownership, or even the people who trained the AI models? There's a fine grain line with regards to this. The Also the underlying question of this is who owns the output of AI? Who owns the output generated by an AI system? And how do we attribute work to the creator or the created, the AI or the creator or the engineer? So therefore there's a nuanced need for legal framework. And I'm glad that this is now coming into practice, although this has been around for quite a while. But thank you.
All right, thank you very much, Miles, for that background definition on the key terms, and also bringing up the controversies and some examples on the topic. We still don't have Mr. Matt on the call yet. So when he comes on the call, I believe we'll be giving him the space to complete his presentation. But while we wait for him, I would call on the presenter for today from the mentees. So the presenter for today, it's over to you. You can share your screen, unmute yourself, and start your presentation. Kindly note that you have 20 minutes. You're muted.
Afternoon.
Okay. Yeah, afternoon.
Okay, I'll be sharing my screen now. Sorry, please, can you see my screen?
Yes, we can see your screen.
Okay. Sorry, I'm coming. Okay, good afternoon, everyone. My name is Beniangba Favor, and I'll be presenting for both Group 1 and Group 2 because we'll be merged together. And our topic is safeguarding intellectual property in the age of AI, protecting creations generated by AI with a focus on ChatGPT. All right, so this is the table of contents I'll be working with. So I'll move straight into the introduction. So as we all know, there's a rapid advancement of artificial intelligence. I'll just use the term AI because it will be coming up in several places. So I'll just use AI. So there's a rapid advancement of AI, and it is reshaping intellectual property protection, especially in handling AI-generated content. And then this has brought about challenges to traditional methods of safeguarding IP, such as copyright, patent, and trademark laws. Sorry, I'm trying to. I'm sorry, part of the video is covering my screen, so I can barely see the content of this.
You can just stop your video and just do your presentation.
Okay. Okay, can you hear me?
Yes, we can hear you.
Okay. So I'll be all right, so as I was saying, based on the rapid advancement in artificial intelligence, there are traditional challenges as to the method of safeguarding IP, such as copyrights, patents, and trademark laws. So AI technologies like ChatGPT blur the lines between human and AI created content, making it difficult to determine authorship, ownership, and infringement. So we are using ChatGPT as a case study. So most of the content generated from ChatGPT, when you see it, you can barely tell if this is an AI generated content or a human generated content. And based on this fact, there's a blurry line between content and AI generated content, which is bringing up the challenges we have right now as to which should be protected by the laws of intellectual property. So the ease of reproducing and sharing AI-generated works further complicates enforcement efforts, highlighting the need for updated legal framework to address these novel challenges. So as I said, when we cannot really differentiate between the human-generated content and AI-generated content, you can barely tell which of them should be protected by the intellectual property laws. And then I don't think we have decided cases in Nigeria unless we are using international precedents to decide on which of these should be protected. All right, moving on. We have to understand AI generated contents. And then in understanding AI generated content, AI generated content describes artistic creations made in response to user instructions by AI systems such as ChatGPT and DALL-E. So when you type in something on ChatGPT, you ask the AI a question and then it gives you an answer. So the answer it gives is referred to as the AI generated content. And then most times they're in form of written text, graphic pictures, musical compositions, and other types of materials. During the course of this research, I actually got to know that with AI, you can get graphic pictures and music compositions. I thought it was restricted to written text only, not until I found out that it also covers graphic pictures and musical compositions. All right. Okay, this also covers what I have just said. So the features of content generated by AI, and then one of it is autonomous creation. So this just means that AI can create creative and unique materials on its own. That's the autonomous creation of AI. It can create creative and unique materials on its own. The high data utilization, it just means that by learning from vast data, AI can produce new materials that is different from its sources. Speed and efficiency, using ChatGPT, for instance, once you just type in something and you ask the AI a question, it brings out the answer in a very fast pace. It's really fast and mostly efficient, as we all say it is. Then possibility for originality. So AI can produce fresh interpretations and combinations that are inventive and original, depending on the data it was trained on. So we've established that AI is not independent. It is dependent on what it has been fed with. So whatever the AI has been fed with, that is what it will produce. So if it has been fed with original works, that is what it will produce. It's more like garbage in, garbage out, just as the presenter said 2 weeks ago. It's what you fed the AI with that it will produce. The AI can't give what it doesn't have, basically. All right, moving on. The legal framework for IP protection. So there are other legal frameworks for IP protection, but the major ones are the Copyright Act 2022. This just repealed the Copyright Act of 2004, if I'm not mistaken. And then the Copyright Act, it focuses mainly on the governance and protection of rights in musical and artistic work. Then the Patent and Design Act 2004, it governs and protects the rights of inventions that extend to things like machines, devices, and manufacturing processes. And then we have the Trademark Act 2004. It governs the rights on signs or other combinations that's peculiar to particular owners, or the identification of the owner's design, differentiating it from other products, especially competitors. So for trademark, I'll just use Coca-Cola, for instance. So the design of Coca-Cola has been protected under the Trademark Act. So if any other company, let me use Big Cola, for instance. Big Cola has a similar name to Coca-Cola, but it doesn't only cover the names, like similar names. It also covers similar designs. So, excuse me, if Big Cola's design is similar to Coca-Cola's design, thereby confusing the users out there as to the originality of Coca-Cola, then Coca-Cola can sue Big Cola for trademark infringement. That's basically what trademark is all about. All right, so the ownership of AI generated works. The ownership of AI generated works cannot be pinned down to a person, because there are controversies as to whether the works are a product of human creativity or purely algorithmic outcomes. Just as the last speaker just said, you can barely tell who really has the ownership or the authorship of AI generated content. Do you want to say it is the person that created the AI, or the person that produces the data that the AI works with, or the general public? So we can't really pin down the ownership of AI generated works to anyone. Yet some people argue that the ownership should belong to the entity controlling the AI system, while others are contending that human involvement in the creation process warrants copyright protection. I think this is under Section 2 sub 2A of the Copyright Act, that has to do with some human efforts being shown in the creation of the work. And then if that can be proven, then the work will be protected under the Copyright Act. But it is not still totally acceptable, because we do not have, as I said earlier, we do not have existing legal frameworks in Nigeria and legal precedents as to the determination of who really has the ownership of AI generated works. Okay, sorry, please, can we still hear me?
Yes, we can hear you.
Okay, thank you. So I'll be talking on some examples of legal precedents. We are using international precedents. So in 2018, a portrait created by an AI program called Edmond Bellamy was sold at auction for over $400,000. The debate arose over who owned the copyrights to the artwork, with some arguing that it belonged to the creators of the AI algorithm and others claiming that it should be in the public domain. I think the last speaker spoke about this case. So someone created a portrait. He used an AI program called Edmond Bellamy to create a portrait, and he sold it for about 430,000 US dollars. And then there were debates on who actually owned the copyright of the artwork. Some people were arguing that it should be the creators of the AI algorithm, and some were claiming that it should be the public domain. And then another case was the song Daddy's Car, that was created by an AI system trained on Beatles songs. The resulting composition sparked discussions about ownership and copyright, as it closely resembled the style of the Beatles music. So this was also a controversial case as to who really owned the copyright of the song, whether it was the creators of the AI, or because there was an issue as it's closely resembling the style of Beatles music. So was it Beatles music that had the copyrights over that song, or it was the originators of the AI system? And so, yeah, we also need to note that there is no universally accepted legal framework for determining ownership of AI-generated works. The approach varies depending on the jurisdiction and specific circumstances. I think in the US government is of the opinion that AI-generated works cannot be protected under copyright because copyright um, is supposed to protect human-generated works and not AI-generated works. So that is the position in the US government. And so it varies depending on the jurisdiction and the specific circumstances. Okay, IP protection strategies for AI. I've just spoken about this: copyright, patent, trade secrets, and licensing agreements. I won't really dwell much on this. Okay, ethical considerations. So the ethical considerations is just talking about the things that should be noted when dealing with AI and intellectual property laws, and that's intellectual property rights. That's, as we mentioned, the Patent Rights, the Copyright Act, and the copyrights and the trademark rights. We need to also take note of misrepresentation and deception. So when you can't really tell um, who has the um, who has the authorship or ownership of AI generated content, it can lead to misrepresentation and deception because you can't really pin it down to anyone. We also have privacy violations. Privacy violations in the sense that if AI generated contents are gotten from already copyrighted works, then there's a violation of the privacy of the owner of that copyrighted work. We also have bias and discrimination, and then unintended consequences. Okay, international perspectives and challenges. We have the variation in IP law jurisdiction. Global IP rights for AI-generated content vary. USD-based copyright protection for such works, exemplified by Steven Tyler's case. Chinese courts recognize AI-generated content under specific conditions, showcasing the complexity of addressing AI's IP right. Just as I said, in the US, in this Steven Tyler's case, it was still a controversy as to if AI-generated works should be protected under copyright, and yeah, they are of the opinion that it should not be protected because it is supposed to protect human-generated works. We also have global efforts to harmonize IP regulations. So global initiatives like the EU's Artificial Intelligence Act and China's measures aim to regulate AI content, ensuring transparency and user safety while balancing innovation and intellectual property protection through collaborative efforts. Okay, the future outlook. And one of it is the recognition of AI as an inventor. So I feel like the legal reforms should involve acknowledging AI as a non-human inventor, thereby clarifying ownership and incentivizing further AI development. So if AI can be recognized as a non-human inventor, I think it will further help to protect AI-generated content. We also have revisions on copyright laws. If an amendment is done on the copyright laws, it could permit the use of copyrighted materials for AI training, resolving existing ambiguities. We also have adaptation of patent rights. When modifications are done to patents and IP rights, it may accommodate IP's predictive capabilities and portfolio management. And the last one is ethical guidelines. I think this is crucial in AI to maintain ethical standards in innovation and creativity, ensuring responsible AI-driven advancements. Okay, so the recommendations we have are clarifying authorship. As we have mentioned, we do not really know who the authorship or who the ownership of AI generated works dwells in. So I think if this can be worked on to clarify the ownership and authorship of AI generated works, it will go a long way to bring in the protection of intellectual property laws in AI generated content, evolving trademark laws, redefining patent ownership, standardizing AI attribution, and promoting collaboration. So in conclusion, AI is radically transforming the scope of intellectual property law, presenting several challenges and opportunities that demand a reevaluation of existing IP regulations. The intersection of AI and IP law spotlights several important issues that necessitate a dynamic and adaptive approach to ensure the continued relevance and effectiveness of IP laws in the face of technological advancement. So in conclusion, since AI is evolving, technology is evolving, I feel like the law should also evolve to catch up with this evolving artificial intelligence and technology, so that it will not be said that technology has gone ahead of the law. I feel the law should also be able to catch up with existing technologies and artificial intelligence frameworks, so that there would be a balance between the law and technology. Thank you.
Thank you very much, Favor, for that wonderful presentation on behalf of your group. Kindly stop sharing your screen right now. Um, I can see Mr. Matt Harvey is back on the call. So I'll be calling on Mr. Matt. Is he still on the call? Okay, yeah. I'll be calling on Mr. Matt to complete his presentation, while also I believe he also heard the presentation from Favor, that's the mentees representative. You can also comment on her presentation, and I would also give the floor to other mentors to give their own contribution to the mentees presentation if there's any correction to be made, or any clarification. But firstly, we would like to get your complete presentation you were making earlier. So
Yeah,
over to you now, Mr. Matt.
thank you. So sorry, my computer needed a firmware update, which could be stopped. I think, let me just share my screen again. I think this is where I got to, and I was talking about copyright infringement, and that, yes, in the US, fair use is a very important exception, which people are going to test in a number of cases. Outside of the US, other countries have, for example, fair dealing exceptions. The UK's is currently quite narrow. It's really for text and data mining from copyright works for non-commercial purposes. There are other interesting exceptions, one for temporary copies, which might allow you to download copyright works, process them, train on them, and then delete them. There has been speculation that might be an arguable exception that allows training on copyright works. Another interesting development in ongoing litigation in the UK is whether pastiche is an exception when it comes to the outputs of an AI, and a pastiche is probably a work in the style of a particular artist or author, or a combination of many copyright works together, and that will be tested if that case comes to trial, which might be next year. Other points to note, there's a concept in many countries of innocent infringement. In the UK, if you've infringed without realizing that the works you've copied were protected by copyright, you may be protected from paying damages. And so it could be that the users of generative AI, if the output is a copy and they're not aware and have no reason to be aware that it's a copy, that they might be protected from damages. I think the only other thing I'll talk about here on this slide, given time, is technical guardrails and ethical platforms. So a lot of suppliers now are trying to train only on licensed works or works they already own or works which are already in the public domain to create ethical AI in terms of copyright. And a lot of them also are trying to implement technical guardrails to filter out requests which might generate infringing outputs, or indeed just to filter those outputs. And a number of AI providers are now offering indemnities to users so that if they end up in a situation where they're accused that an output infringes copyright, that the AI provider will pay their legal bills and cover damages. The next point I want to talk about is rights and outputs, and we've just heard quite a bit about that. In every country so far, other than South Africa, attempts to get a patent on the basis that the invention was by an AI have failed. And so it does appear that to the extent an AI is the inventor, patent protection won't be possible. And again, we just heard about case law and results on copyright. And I think around the world, it seems to be increasingly likely that if an AI generates an image without any real human input, it won't be copyright. That's even true in the UK. It looks increasingly like we have protection for what's called computer-generated works, but it sounds like our law doesn't quite make sense and might not get through a court if it came to being litigated. And then the other thing to remember is there are areas of IP, trademarks and designs, for example, in the UK, where you don't need a human author at all, and there's no theoretical restriction on AI-generated designs or trademarks in the UK. Another point is personality rights. What we are seeing a lot of is deep fakes, including fake news. So this image of the current and the previous US presidents is a fake. They don't play golf together and smile about it. But there are very few, well, there's no harmonized international rights in likeness or voice. You have very little protection in the UK. Only celebrities who make money by endorsing products would have a potential claim. But in the US, by contrast, many states have particular rights in personality, so you are allowed to enforce your rights in your personality and voice. In Europe, there is a variety of different approaches in different countries. Some protect your likeness through human rights or constitutional rights, and you may be able to argue unfair competition if there's some sort of commercial arrangement. And new Chinese regulation on deepfakes does require the consent of a person who's being emulated. I think I'm coming to an end here. One other point, open source. So a lot of computer code is copyright, but the person who's written the code allows other people to use it, subject to certain open source obligations, which have a variety of different combinations. It may be that you have to acknowledge that it's open source. You may need to license your own work if you use open source code in it. And there is concern that if you've trained an AI on work subject to open source obligations, that the outputs might also be subject to those open source obligations. Let me just check if I had slides. No, one more slide, and that is an interesting development in the European Union. The AI Act, which again was just discussed, has some very interesting developments. If you develop an AI and you want to market it in Europe, you need to publish a summary of the training data that you used. So you're actually telling people who own copyright whether their work was used to train the AI. You have to comply with EU copyright law, including the right of people to opt out from allowing commercial use of their works to train AI. And they appear to want to export this concept. So if you train an AI outside of Europe, you can't bring it into Europe if you didn't comply with European copyright law. And that is the end of my talk, so I will stop sharing my screen. And I apologize again for missing part of the session and part of the previous talk, but I did catch quite a bit of it, and I thought it was an excellent talk, very thorough, very well presented, very well researched. And just to comment a little bit on some of the detail, it was very interesting to hear the summary of international differences when it comes to copyright protection for outputs. And the speaker contrasted US results with one in China. And I think there's actually, so far, I think international positions are actually relatively similar, and the differences in the outcomes in the cases have been on the level of human involvement in shaping the output. So we'll see where that ends up. I do think it's extremely hard to gain international harmonization in this field. It's very new. Different countries have different interests in whether they want to promote technology or the creative industry. A lot of countries are worried about certain countries dominating AI and may not want to encourage AI further through changes to IP law. And we'll see where that comes out. The speaker did talk about harmonization of, or the development of IP regulation. I think it's fair to say that most of the regulation isn't really focused on IP. It's really focused on responsible or ethical AI or safe AI. IP does come into some of it, but I don't think that's the primary focus of most activities to regulate AI. There are some international bodies trying to develop at least dialogue, if not harmony, when it comes to IP, and the UN and its entity, the World Intellectual Property Office, has been leading efforts in that regard. If I were to pick one or maybe two things that I think international bodies could really get involved in, the first is patent protection for AI inventions. And I think that shouldn't be so controversial because it's not a choice between human creativity and values in AI. It's about getting new medicines, which are, I think, clearly of benefit to mankind and womankind and personkind in general. And I think there are potential problems in some industries, particularly life sciences, where it costs a lot of money to get a product to market, and you really need to have a patent or some sort of monopoly right to make that economically viable. I think another interesting thought I heard earlier this week is that it would be great for an international standard to allow rights holders to express an opt-out about their use of their works in training. So in conclusion, again, I'm sorry I didn't hear the whole presentation, but I thought it was really excellent. I'll be delighted to answer any questions or discuss any points further after the other mentors. Thank you.
Thank you very much, Mr. Matt, for completing your presentation and also contributing to our mentees presentation. So I'll be calling on Professor Samuel to give us his own contribution. Prof, are you still on the call? Okay, while we're waiting for Prof, we can have my contribution before we move on to Prof.
Great. So first of all, I found it unique that this week's presentation was drawing on specific case studies. I found that in the previous weeks of doing the program, not many students had drawn on that. So it was refreshing to see specific targeted examples of the week's topic. coupled with the framework acts for IP and patent, trademark, and copyright acts. I think overall the presentation was concise. Having gone through it last night, I found that the categorization of the topic was concise. It was easy to follow, and there was one other thing. It was it was the fact that additionally with other students, the expansion on certain points hadn't been as open as I would have wanted them to be. This week's was to the point. There wasn't any extra additional information that was irrelevant for the topic. I found that this week had nailed focus on what IP was, what IP, the issues of IP, the ethical considerations of IP, and just general worldwide implementation of it and regulation. It talked about China's measure, it talked about US debates for copyright. It was a good presentation and it was easy to follow. So thank you.
Okay, thank you very much, Miles, for your contribution. I will be calling on Prof. Samuel once again to get his own contribution before we move on to the next. I don't know if we still have Prof on the call. Prof. Samuel Samai. Okay, while we're waiting for Prof to join the call, I would encourage everyone on the call to turn on their videos. We all know how we do it here at JIIPC. So we'll be taking screenshots of the session for our social media posts. Yeah. Okay. All right, let's smile for the camera. Thanks. Okay. I believe we've taken some screenshots. So we'll be moving on to the question and answer session now. I believe after listening to our mentors, most of our mentees would have lots of questions. So just raise your hand and I'll call on you to ask your question. Okay, Prof is back. Yeah, Prof, you missed a lot. So we just finished taking the picture session. You're muted.
I was actually here. I just
Yeah.
I was multitasking. Yeah, I heard that Matt is concluding. I listened to Matt Harvey's concluding speech. Yeah.
Okay. So we are asking for your contribution to the mentees presentation.
Well, I mean, it was well detailed, but my only concern and comment I always have for them is that because presentation is an art, and it's even for we experts, or so-called experts, who have been doing it for a while, we still have to practice. So I am always looking at your presentation should not be too clustered. I mean, your templates, on the quality, quality of what they did good. But I'm just going to talk about the presentation itself, because you see, the essence of, as a teacher, which I teach a course, a project course, teaching law students how to do oral presentation. So it's always good for you to make your presentation nice, sexy, you don't cluster. You can see, take example for look at the example Mr. Heve look at his presentation. See his PowerPoint. It's not clustered, because your PowerPoint is for me, it's for the audience. We are trying to follow, but you can't talk about intellectual property in 20 minutes. It's too broad. You can't talk about copyright in 30 minutes. So you have to narrow your presentation to the relevance of the topic, or you narrow it down. You always narrow your topic down. If you're talking about how to safeguard AI with intellectual property, narrow it down to talk a lot of histories and all that. So we are not interested in histories, because most of us already know the histories. So you try to make your presentation a little bit, like I said, make it beautiful to the eyes. So I was having problems, and I tuned off reading your slides. I mean, because there are too many things you're jumping in there. So that's the only comment I will make. But for your quantitative, and in terms of the quality, like I always say, you're always doing a good job. You're always coming up with a lot of industry, and that was good. Yeah.
All right, thank you very much, Prof. Samuel, and to all our mentees. I believe we've all listened to the contributions from all our mentors, and it would be nice for us to take corrections and also improve on our presentations. So I'll be handing over to my colleague, Mr. Dennis. So I'll be leaving the call and the questions for Summers and it was really enlightening listening to you. Mr. Matt Harvey, thank you also, and Mike Isaac. So over to you, Mr. Dennis.
Hello, everyone. Good afternoon. My name is Dennis, and I'll be continuing or just taking over from where Mr. Hussein stopped. It has been an interactive session so far. I want to say a big thank you to all our mentors that have been here with us, sharing their insights and their knowledge with us. And I'm sure that this last part where we'll be asking questions will be very interactive. I expect a very interactive discourse from our mentees. We have quite a number of mentees on call. So please, I really want us to engage our mentors to the best of our ability. So please, if we have questions, we're about to take questions. At least a couple of them will not be bad, right? So please, our mentees, go ahead and ask your questions. A question was sent to us from the mentees, and I'll be sharing it in the chat box. And we'll just be reading it first, and then we'll just have our mentors help us answer that question, and then we'll be taking other live questions from our mentees. So the question we have here on the chat box is, we have questions regarding the legal framework and the application in different jurisdictions of the world. Also, we also need the general accepted perspective so far regarding the ownership of AI generated works. So that's the question our mentees put together after the research. We don't know if our mentors have any perspective as to this particular question and insights that they would probably like to share. I would just like to give an open floor to our mentors to see if they can jump on the questions and help with that. Professor Samuel, I can see you're unmuted. So, do you have a perspective as regards this particular question?
Well, it's still ongoing. It's still ongoing. I think I predicted somewhere in one of my papers that at the end of it, because this is now about where policy meets politics and reality. If I understand the question well, it's still whether AI can own the creative rights or innovative rights. Whether AI, is that the question? Whether AI can an artificial intelligence can own patents or can own copyright or can own trademark. That's the essence of what the
Yes,
question
sir.
is, and how the jurisdictions are approaching it. So it's ongoing. And South Africa tried. What I'm saying is it's a bit political, and it's going to be a bit reality. Is that currently we all know, we are familiar with the history of IP. IP was made for human beings, for us. The beneficiaries of IP were for humans, persons. So in all the laws in all the continents, before now, patent, copyright, trademark, especially patent and copyright, it's legally stated there in US, in UK, Britain, America, everywhere. You see the law there. Even in Nigeria, it's there, person. And in some of the laws, it's in the definition, interpretation sections, it even tells you who a person is. So now, this is my opinion now. I've written it somewhere. I've been 3 papers. I've written something about 3 papers. Now, you will have to change the law. There's not going to be any shortcut. It's gone to the Supreme Court. I think it's in the UK Supreme Court, Matt. I think it's one of them is in your court now, in the Supreme Court somewhere.
Yeah, so Davis patents has been decided in the
yes.
Supreme Court, and they could not have a patent if it was AI generated.
So in America, it's the same position. So China recently, about 2 weeks ago, it wasn't really clear because I read the case, but it wasn't really clear whether they are saying that but you can see South Africa tried something like that, but of course it wasn't taken seriously. So it's going to be a really serious. Our friend Dr. Ryan is in the forefront for patents, of trying to make sure that patent owns IP rights. So, but it's going to be it's going to be a political issue. Let me put it that way. Meaning, the law has to be changed, but you have to look at all the major economies for them to agree, because there's a lot of implications for me. It's going to be a lot of implications for you to say that machine will now start owning rights, copyright, and all that. So I'll let Matt take it from there, maybe. Yeah. So it's right now, no machine, no AI can own any IP. You can't. No machine can own it. It's only human beings. But let's see how it goes.
Okay, thank you so much, Prof. Mr. Matt, you have any other thing to add? Okay.
So first of all, I definitely want everyone to keep in their mind separately whether there's an IP right and who owns it. And Professor Samuel is absolutely right that AI is never, well, currently cannot own anything. It's not a legal person in any jurisdiction, apart from, I think, some slightly novel ideas. I think a robot was made a citizen in Saudi Arabia, but as a sort of publicity event. So definitely, let's leave ownership to one side. The IP will be owned by a person or by a company if there's IP at all. So the court cases have been focused on whether there's any IP. As I said in my talk, there are some forms of IP where it simply doesn't matter if an AI created it. So a trade secret could be created by AI, a trademark could be created by AI, and at least in the UK, a design can be created by AI without any issues. The other thing I'd say is that the situation is just random. It's arbitrary. Most of IP law was written before anyone had considered the possibility of generative AI. To give you an example, European patent law was essentially written in the 1960s. So it's not really surprising that it doesn't deal with AI in any direct way. Now, I think there is so far harmony everywhere and where it's been tested on whether an AI generated patent is allowed. And the other thing you need to distinguish is AI assisted and AI generated. These cases, these test cases, have been about autonomous generation of an invention where a human is claiming, no human is claiming to have any meaningful involvement in the invention. In those circumstances where they have named an AI as inventor, everywhere in the world that patent has not been allowed. There have been two exceptions. The first is in Australia. The lower court allowed it, but that decision was overturned on appeal. So Australia, it's over. The other exception is South Africa, but in South Africa, a patent is granted without an examiner looking in detail at the application. So that is not considered to be a decision by the South African authorities that an AI is allowed to create a patentable invention. It's more that the issue wasn't actually tested there. I think this is an important area for international harmonization if possible. The UK considered changing its law to allow patents by AI, but decided that there was no point in a single country making a change because the value of a monopoly in a single country isn't really going to incentivize companies to use AI to make inventions. So this needs international harmonization. It will take a very long time. And I do think it's a priority for international organizations like WIPO to drive that debate forward. Copyright is a bit more mixed. So on copyright, there are a handful of countries which expressly allow for computer-generated works. The first, I believe, was the UK, and they introduced a special provision for computer-generated works back in the 1980s. But there have been really no cases other than one in all of that time. So we don't really know how that's going to work out in practice. I think the UK law was the model for similar laws in Ireland, South Africa, India, and Hong Kong. And again, I don't know if those laws have really been tested. I think, at least for Ireland and the UK, I think there's increasing belief that those laws don't in fact work. And if it came to a court case, that the judge would not allow copyright in a work made exclusively by AI. Now, for the rest of the world, and I think probably in the UK and Ireland as well, what you're looking at is to identify if a human should be considered the author or the artist of the work. And that will all come down to their level of involvement in the final output. I think the most extreme cases have been in the States, because in the US, they have a copyright office and you can register copyright. And so people have actually tested this issue. Davis created an image and was not granted copyright because no human was involved. But to take a very extreme example, an artist called Jason Allen created a work called Space Opera Theatre, and he went through a process of 600 prompts before he was happy with the output. But the US Copyright Office decided he did not actually control the expression that the AI produced, even though he had asked it to produce so many images and had chosen the one he liked. He hadn't controlled the actual expression, because the technology doesn't allow you through a text prompt to exert real control over the way something looks when it comes out. And I have to say, I agree with that. I think under our conventional copyright law, it is the case that it is very hard to use these tools in a way that I have an idea of how something should look or how something should be expressed, and to control the output in a way that I can say that it is my expression that's been recorded, as opposed to me pressing a button or asking for an idea and then seeing if I like the way it's been expressed and deciding whether to use it. I think that is too complicated an issue to expect international harmonization in the short term. And I don't think there's much agreement within countries, let alone between countries, on whether copyright works should be allowed where they were wholly AI generated. And the reason that's political and complicated is whereas I think patents are clearly beneficial, not all, we may want to prefer human creation, even if AI creation is possible. We may want to avoid AI creation on ethical or human dignity grounds. And I think that is something that individual countries need to decide for themselves. Yeah, I think that's my answer to where we are. And then the question was legal frameworks and applications, different jurisdictions. There are international treaties for copyright, so the Berne Convention, the WCT, TRIPS, and they set out the minimum level of protection for copyright around the world. At the moment, none of them deal with computer generated works. And then when it comes to patent protection, there are regions, for example, Europe, where people have come together to agree the rules for patent protection. But again, they don't deal with AI generated inventions yet. And international treaties on IP can take decades to agree. So I don't predict that there will be new treaties anytime soon to deal with AI.
All right, thank you so much, Mr. Matz, for that answer. So much, Mr. Professor Samuel. Also, I just want to ask if Mouse Isaac, Mr. Mouse, if you still have any perspective or okay, we are still asking questions. Please, mentees, you can raise your hand or indicate, and we'll just take your questions. Please, are there any questions from our mentees? Any live questions? Do we have any live questions? Okay. All right. In the absence of any live questions, I think it's fair to call it a day. Right. It's been an interesting hour and 30 minutes, hour and 40 minutes in class. Our mentors have done their very best to try to explain to the best of their ability the scope of IP protection in artificial intelligence, specifically focusing on ChatGPT. And our mentees have also done so well in coming up with that presentation, wonderful presentation that our mentors were able to also shed more light on. So thank you to all the members of the artificial intelligence group that were able to come up with their presentation. Thank you to the presenter for a wonderful presentation. And with that, we've come to the end of today's session. Thank you to our earlier moderator in absentia, and to Mr. Gabriel also in absentia. I wish everyone a wonderful day ahead, or just rather generally enjoy the rest of your day. So goodbye, everyone, and enjoy the rest of your day. All right,
Thank
take
you
care,
very
sir.
much.
Yeah,
Bye for
bye
now.
bye, sir.